indigenous people of Biafra, IPOB, has told the Court of Appeal, Abuja Division, that the memo written by the Attorney General of the Federation, AGF, and Minister of Justice, Abba Malami, SHÄME, to President Muhammadu Buhari, which was relied upon by the Federal High Court to prescribe and declare it a terrorist organization, was signed by the late Chief of Staff to the President, Alhaji Abba Kyari. IPOB said the signing of the memo by Abba Kyari contravened the clear provisions of the Terrorist Prevention Act, which provided that the approval shall be signed by the President of the Federal Republic of Nigeria. In an amended brief of argument filed in the appeal challenging the proscription and clarification of the group as a terrorist organization, IPOB further accused the federal government of Nigeria of discrimination against it by proscribing its activities and declaring it a terrorist group. The Honorable Trial Court not validates the unconstitutional behavior of the respondent discriminatory act by applying for the declaration and proscription of appellants, and the President purportedly approving the same, whereas their Fulani herdsmen, the fourth most deadly terrorist group in the world, who move freely with AK-47, murdering, killing indigenous people all over Nigeria, and grabbing their land, were never condemned or proscribed, and whether there was even a valid approval by the President. Specifically, the appeal marked AC/A/214/2018 and filed by the lead counsel to IPOB, Mr. Chukwuma Machuku Umem-san, is querying the decision of the Abuja Division of the Federal High Court in suit number FHC/ABJ/CR/871/2017, prescribing and declaring IPOB as a terrorist group. The federal government, through the AGF, had on September 20, 2017, approached the trial court via an ex parte application pursuant to Section 2(1) of the Terrorism Prevention Act 2013 to declare and prescribe IPOB as a terrorist organization, among other reliefs. The former Imo State AGF said, upon information gotten on the newspapers, his client on September 22, 2017, applied for the setting aside of the order of the trial court made on the 20th September 2017. Dissatisfied with the entire ruling of the trial court, IPOB appealed the Court of Appeal, urging it to set aside the decision as well as the consequential orders made by the court. But in its amended grant of appeal, IPOB said the purported presidential approval as contained was simply a memo written by the Honorable Attorney General of the Federation to the President dated 15 September 2017. On the ex-AGF 11A and 11B, see page 57 to 61 of the Record of Appeal, to President Muhammadu Buhari, and was curiously signed by Abba Kyari, the then Chief of Staff to the President, contrary to the unambiguous provisions of the Terrorism Act, which specifically provided that the approval should be signed by the President of the Federation for the President of Federal Republic of Nigeria. Laws a cursory look at the memo of the Honorable Attorney General of the Federation dated 15th day of September 2017 addressed to President Muhammadu Buhari and the said presidential approval exhibits AGF 11A and 11B, pages 57 to 61 of the records of appeal, which the trial judge relied on as constituting the mandatory presidential approval, shows that it was a main memo from the Attorney General of the Federation to the President requesting for the said President's approval as prescribed under Section 2, 1 in bracket, C in bracket, of the Terrorism Prevention Amendment Act 2023 and not the mandatory President's approval envisaged under the Act. We therefore submit that, having not been signed by the President of the Federal Republic of Nigeria, there was no evidence of the presidential approval before the trial court as required under Section 2, 1C of the Terrorism Prevention Amendment Act 2013. More so, under Section 40 of the Terrorism Prevention Act 2011, which deals with interpretation of words or phrases, the word president as used in the Act refers and only means the president. It is equally your further submission that the Constitution of the Federal Republic of Nigeria 1999 under Section 5 neither mentions nor contemplates any form of delegation to the Chief of Staff to the President as an officer to whom such crucial executive function of the President can be delegated to. In fact, the decision to approve the proscription of a group or organization as a terrorist group is one of discretion to be personally exercised by the President of the Federal Republic of Nigeria, which was regrettably delegated to the Chief of Staff, contrary to the well-established rule against sub-delegation, which states that a delegate cannot sub-delegate his functions and powers. Hence, the Latin maxim delegatus non-protest delegere means that the delegate cannot delegate his functions unless he is otherwise authorized or permitted to do so. This is especially where he is required to personally perform the delegated function or exercise the power concerned. That the office of Chief of Staff to the President is not one of the offices mentioned in X5, 1, A and B of the Constitution of the Federal Republic of Nigeria 1999 as amended, to which the President can delegate his powers and functions. The principal canon on interpretation remains that the express mention of a thing is to the execution of all others. IPOB Pr0scripti0n, Malami's Memo to Buhari was signed by Abba Kyari, IPOB tells Appeal Court. So guys, I'm dropping it here. Kindly share your thoughts below.